Welcome everyone to the second annual Faculty Showcase series. We welcome our students and alumni, faculty, staff, and friends of the law school here to the first of what is going to be 7 free CLE lunches this year. We've just added, we were going to have 6, but we've just added a 7th on the first Monday in October. It's actually going to be an evening session when one of our professors, Professor Robert Fu, who clerked for Second Circuit Judge Sonia Sotomayor, is going to speak about the new Supreme Court term and some insights on now Justice Sotomayor. But today we have the pleasure of hearing from Professor Lynn Entzeroth about her work on the death penalty. Professor Entzeroth truly embodies excellence in teaching, excellence in scholarship, and excellence in service. For those of you who are part of the law school knows that those are the really 3 key areas that we as professors focus our energy on. As far as teaching, Professor Entzeroth teaches constitutional law. She teaches a death penalty seminar. She teaches federal courts, and I understand we have lots of students from federal courts here. But she not only teaches these classes, she, year after year, achieves absolute excellence. Her wall, there's no more space on the wall for the teaching awards that Professor Entzeroth has received, from the university-wide teaching awards to law school teaching awards. And I recognize here her current students, but also many former students who I know are very, very loyal to Professor Entzeroth. Likewise, Professor Entzeroth maintains the highest standards of scholarship. As I've said in many different settings, she literally wrote the book, the first textbook on the death penalty, a textbook that is used widely throughout law schools around the country. She's also recently published articles both in the Tennessee Law Review and in the Indiana Law Review, both really top-notch law reviews on some of the research that I believe she's going to present today. And as far as service to the law school, Professor Entzeroth just finished a 2-year term as Dean of Faculty Development, where she really created a program from scratch, and I'm deeply, deeply thankful for that work. But also her work before entering academia shows the utmost commitment to service, particularly service around some of the causes that she cares about so much. She was an assistant appellate public defender. She was a senior law clerk to Judge Chappell of the Oklahoma Court of Criminal Appeals, and was a law clerk to U.S. Magistrate Judge Dana Roberts in Oklahoma City. So we are so lucky that she now lives at the other side of the turnpike, and we welcome Professor Entzeroth.
Thank you, Dean. I really appreciate those kind words, and it's nice to see you all here out on a lunch to offer you. Just hope the talk lives up to the lunch. Our Faculty Showcase series that the Dean was telling you about, as I understand it, it's designed to let you know what the various faculty at the College of Law are doing. Now, I know you know what we do in the classroom, from scaring first-year law students, my favorite thing to do, to talking about some strange, esoteric aspect of the law. And for me, what happens in the classroom is one of the most rewarding things in my life. Training the next generation of lawyers, not just to think like a lawyer, but to be aware of and care about the important issues that they're going to face in practice. But another part of being a professor is the responsibility, coupled with the luxury, of having the time to think about, research, write, and talk about important aspects of the law. Now, I practiced for quite a while before I started teaching, and I did write articles while I was in practice, but it was really hard to carve out the time in practice to do the work at the level and with the commitment that I wanted to do. it's particularly hard for me to carve out that kind of time because it takes a lot of time to really think about, to delve into an area of the law. So one of the other great parts of my job is I now have the time to really think about and write about and study and research the issues that are appealing to me. And I have to mention this too, because we have such wonderful students. I also get research assistants who help me with these things. And this summer, I see one of them back there, Lisa Mazumder, who I think does work with the Public Defender's Office, and Megan King, who's not here yet. They help me with my research. And working with students on that is also incredibly rewarding. So what I'm going to talk to you about today is some of the research I've been working on, and hopefully provide you with some ideas to think about, talk about. I'm hopefully going to have enough time for questions at the end, and if you'd like, I don't have a class after this, so I'll stay after and be happy to talk to you about it. One of the areas of the law that I study and write about is the death penalty. A bit grisly, perhaps, to spend one's day thinking about the death penalty. But for me, the decision of a government to impose and then carry out the death penalty is one of the most difficult and important decisions a government makes. It's difficult legally, morally, it's even difficult medically. And the stakes in capital litigation are so high because at the end of the day, what the state wants to do is stick a needle in someone's vein and pump chemicals in there for the sole purpose of ending that person's life. And the stakes are high because the person who's to be executed has committed a crime of murder with all the pain and horror that goes along with the violent death of another human being. So I think as long as we're in a society that's engaged in meting out this kind of a death penalty, having this as part of our legal system, part of our culture, then it's the responsibility of people like me who have the interest and the time and the resources to look at this issue to really take up that cause and do that. Now, the death penalty raises many interesting and provocative issues, from the question of whether or not we have executed anyone who's actually innocent, an issue that's a big deal right now in Texas, to the appropriate mixture of chemicals that we use in the syringe that we stick in someone's arm, to the role that race plays in the sentencing decision, to how you select that juror who can sit on a jury to decide whether to impose life or death. I'm going to talk about one fairly discrete issue about the death penalty, and that's the constitutionality of the imposition of the death penalty on the severely mentally ill. Now, I call this a fairly discrete issue, but it's not insignificant. It's been estimated that anywhere from 5 to 10% of death row inmates suffer from severe mental illness. You figure roughly about 3,300 people are currently waiting execution on death rows around the country. We're looking at perhaps 165 to 330 condemned prisoners who currently suffer from severe mental illness, not to mention those offenders who may be coming through the system who have severe mental illness. But to do this discussion and make it understandable about the constitutionality of this question, what I'm going to do is spend some time on the background of the death penalty, and then I'm going to discuss some cases and the legal issues that surround and are relevant to the question of whether or not the execution of the severely mentally ill is constitutional. Now, historically, challenges to the death penalty have been grounded either in the 14th Amendment Due Process Clause or in the 8th Amendment Cruel and Unusual Punishment Clause. And while the death penalty has been carried out in this country in, the 18th, 19th, 20th, into the 21st century, there are states that have abolished the death penalty. Michigan was the first. It abolished the death penalty in 1846. And most recently, New Mexico, this past spring, abolished the death penalty. Now, in the 1950s and 60s, public support for executions in the United States was really declining, and actual executions started to decrease. By the late 1960s, although many states and the federal government still had the death penalty on the books, actual executions had stopped. And there were a number of people who thought that the death penalty in the United States was just going to fade away, like was happening in a lot of Western Europe. And it was in this setting that the Supreme Court in 1972 decided Furman versus Georgia and ruled that the death penalty that existed at that time in the United States was too arbitrary, too capricious, too unpredictable in its application, that it gave too much unrestricted, unguided discretion to juries in deciding whether to impose a death sentence. And because of these defects, a majority of the court found then existing death penalty systems violated the Eighth Amendment of the Constitution. Now, I haven't put the Furman case in your written material because it's incredibly long. They issued basically, the judgment was issued in a per curiam opinion, but each justice, all 9 of them, wrote an opinion. 5 of them setting out their differing reasons why they thought the death penalty was unconstitutional, and our 4 dissenters setting out their separate reasons as why they thought it was constitutional. And the effect of Furman was to render void all death sentences in the United States at that time. And so those individuals who were on death row were then had their sentences, I think, most commuted to life, and it rendered all death penalty systems around the country. Now, many folks thought Furman, once again, would be the end of the death penalty in the United States. But at a state level, various groups began to advocate, reshape, and try to reinstate a death penalty system that addressed the concerns of Furman. And as a result, during the early 1970s, a number of states enacted revised death penalty statutes. In 1976, the Supreme Court granted cert to decide the constitutionality of these newly minted death penalty statutes, and they did it in a case called Gregg versus Georgia, plus 4 companion cases. And in all, the court looked at the revised death penalty statutes of 5 states: Georgia, Florida, Texas, and then North Carolina and Louisiana. But the first issue the court had to deal with when they were looking at the constitutionality of these statutes was to decide whether or not the death penalty was ever constitutional. Because one of the issues the court avoided in Furman was saying whether or not the death penalty was a per se violation of the Constitution. So that's the first issue the court had to deal with in the Gregg case. And in deciding whether or not the death penalty could ever be considered completely unconstitutional, the court looked at several factors. First, the court looked at the long common law history of the death penalty and the fact that after Furman, 35 states reinstated the death penalty. And the court said this was evidence that the death penalty was something that was tolerable in the United States, but it was not dispositive of constitutionality. Instead, the court said the ultimate question was whether the death penalty, quote, comports with the basic concept of human decency at the core of the Eighth Amendment, end quote. Now, the court recognized and said the death penalty is unique, both in its severity and its irrevocability. But the court found that it could arguably be said to serve 2 goals, 2 social goals. One is retribution, and the other was deterrence of future capital offenses. With respect to retribution, the court said that for many folks, this is an unappealing goal, and that really the primary goal of criminal justice, at least in the mid-70s, was no longer retribution. But the court said this is not a forbidden objective, and it's not inconsistent with the dignity of man. As to deterrence, the court recognized that, at best, the evidence is inconclusive whether the death penalty is an effective deterrent. But they said it's a complex issue. We're going to give it back to the states and let them work that issue out. So the court ultimately concluded that to the extent the death penalty can be said to advance the goals of retribution and deterrence, it is not a per se violation of the Eighth Amendment. And the court then turned to the new death penalty systems to figure out what was constitutional and what wasn't. Now, in Furman, the court found that unguided, uncontrolled jury discretion in imposing death sentences is too arbitrary, too random, too capricious to withstand constitutional scrutiny. North Carolina and Louisiana said, okay, we'll have a mandatory death penalty system though. No discretion, no problem. Supreme Court disagreed. Just as having too much discretion was a problem in the Furman case, the court said having no discretion is also constitutionally flawed. Juries have to have some discretion to impose a sentence less than death. The court then turned to the statutes in Georgia, Florida, and Texas. And these systems, to varying degrees, allowed at least some jury discretion, but were also designed to arguably provide guidance in the imposition of the death penalty by devising and demanding the existence of certain aggravating factors that would distinguish the death penalty case from those in which death is not an appropriate punishment. And these cases, Furman in 72 and Gregg and the companion cases in 76, really form the constitutional basis of the modern death penalty system in the United States. And basically what we see is a majority of the court concluding that to the extent the death penalty carries out the legitimate goals of retribution and deterrence, it is not a per se violation of the Constitution to have that penalty. And statutes that provide jury with criteria, usually aggravating factors, to guide their sentencing discretion, and yet give the jury discretion, often based on mitigating factors, to impose a sentence less than death, those are generally going to be constitutional. But really, this is too easy and too simplistic of a constitutional formula to address all the concerns of a system that allows a state to kill a person, even a person who's been convicted of a capital offense. And there have been many criticisms of this system, including from Justice Blackmun, who came to view the modern death penalty system as constitutionally intolerable. Most recently, Justice Stevens, in last year's lethal injection case, said, quote, "Current decisions by state legislatures, by the Congress of the United States, and by this court to retain the death penalty as part of our law are the product of habit and inattention rather than an acceptable deliberative process that weighs the cost and risk of administering that penalty against its identifiable benefits, and rest in part on a faulty assumption about the retributive force of the death penalty." End quote. Now, Justice Stevens' misgiving notwithstanding, we do not have a majority on the current Supreme Court who is going to find that the death penalty is unconstitutional, at least on a whole-scale level in the United States. What we see instead is over the last 30-plus years of our death penalty that we have a majority of the court that restrict or limit the scope of the death penalty. And one area we see the court addressing the appropriateness of the death penalty is the question of who the death penalty should be imposed upon. The court said last term in Kennedy versus Louisiana, and that is in your written materials, the recent decision of Kennedy, for the infliction of the death penalty to fall within the parameters of constitutional acceptability, the court says the imposition of the death penalty must comport with the evolving standards of decency that mark a maturing society. And Justice Kennedy, in his opinion in Kennedy versus Louisiana, said, quote, "When the law punishes by death, it risks its own sudden descent into brutality, transgressing the constitutional commitment to decency and restraint." He then went on to say, "For these reasons, we have explained that capital punishment must be limited to those offenders who commit a narrow category of the most serious crimes, and whose extreme culpability makes them most deserving of execution." And he concludes by saying, though the death penalty is not invariably unconstitutional, the court insists upon confining the instances in which this punishment may be imposed. And consistent with this principle, the court has found there are certain groups of individuals or certain circumstances in which the death penalty cannot constitutionally be imposed. For example, in Coker versus Georgia, which is a 1977 case, I apologize, and in Kennedy versus Louisiana, which is our 2008 decision, the court said the death penalty is only appropriate for capital murder. The death penalty cannot be imposed for the crime of rape, even the horrific rape of a young child. Moreover, even when the crime results in the death of the victim, the court demands that the defendant have sufficient knowledge of and sufficient participation in the murder, have a sufficient degree of culpability before the death penalty can constitutionally be imposed. And in addition to these restrictions, the court has limited the groups on who the death penalty can be imposed. For example, in Atkins versus Virginia, 2002 decision, the court held that death penalty cannot constitutionally be imposed on someone who is mentally retarded, although the court left it to the states to figure out the criteria and the process for determining whether someone's mentally retarded and exempt from the death penalty. And in Roper versus Simmons, a 2005 decision, the court said that the death penalty cannot be imposed on someone who was under the age of 18 at the time of the commission of their crime. Now, Atkins and Roper are really important when we're looking at whether the death penalty can be imposed on the severely mentally ill. And I'm going to talk about these two cases for a minute and some of the similarities that they have, because they're going to be relevant to talking about the severely mentally ill. With respect to Roper and Atkins, both of these decisions overturned fairly recent Supreme Court precedent. Roper overturned, which is a 2005 decision, overturned Sanford versus Kentucky, a 1989 decision in which the court found no constitutional problem with executing 16 and 17-year-olds. And Atkins versus Virginia overturned Henry versus Linog, a 1989 decision in which the court found no Eighth Amendment problem in executing a mentally retarded man. Secondly, prior to their decisions in Atkins and Roper, a defendant's youth or mental retardation were generally considered mitigating factors that could be presented to a jury so they could impose a sentence less than death. But with respect to both of these attributes, they could be seen as serving as a double-edged sword, with many jurors thinking that these qualities, youth and mental retardation, as seeing them as evidence that the defendant was more dangerous, more deserving of death. And there was a danger that jurors would misinterpret the evidence of youth or limited intellectual capacity to improperly punish a capital defendant. Thirdly, and I think this is pretty important for the discussion with respect to the severely mentally ill, in both Atkins and Roper, the court found that there are certain characteristics about this group that make the death penalty an excessive punishment when imposed upon them. Most specifically, the court found in Atkins and Roper that the goals of retribution and deterrence were not adequately met by executing these individuals. For example, in Atkins, the court said mentally retarded individuals who meet the law's requirements for criminal responsibility should be tried. They should be punished when they commit crimes. But because of their disabilities in areas of reasoning, judgment, control of impulses, they do not act with the same level of moral culpability that characterizes the most serious adult criminal behavior. And because of these impairments, their ability to get a fair trial and a fair sentencing determination can also be undermined. With respect to retribution, then, the Atkins court found that retribution, and when we're talking about the death penalty, we're talking about the most severe penalty out there, they said retribution really turns on the severity of the punishment. And the most severe punishment demands a high level of culpability. And because of the diminished intellectual abilities of the mentally retarded offender, diminished reasoning, diminished impulse control, the court said, we do not have the level of moral culpability in this group that's necessary for the imposition of the death penalty, for that to have its retributive force. With respect to deterrence, the court in Atkins said, we see the same characteristics limiting the deterrent value of the death penalty in this category as well. These individuals who have cognitive and behavioral impairments, not only are they less morally culpable, but they're less likely to be deterred because of the death penalty. And therefore, the court found that the execution of a mentally retarded offender did not advance either the goal of retribution or deterrence to the degree necessary to make the death penalty an appropriate punishment. The court's doing the same thing in the Roper case. In the Roper case, which deals with juvenile offenders, the court first relied on scientific and sociological studies showing that, as a whole, individuals under the age of 18 have an undeveloped sense of responsibility, they are more vulnerable to negative influences, and their character is not fully developed. And thus, their character is less fixed, more likely to change in the future. The court found these characteristics made juveniles less culpable and less likely to be considered the worst of the worst. And as a result, and for reasons similar that we had in Atkins, the death penalty is less likely appropriate retribution of the act of a juvenile offender. And the death penalty is less likely to deter juvenile behavior. So, like in Atkins, the Roper court said the death penalty, when imposed on juvenile offenders, does not adequately meet the goals of retribution and deterrence necessary to warrant the imposition of the death penalty. But there was a fourth, and in my view, really determinative reason for why the court changed its mind. Why in 1989 the court said, it's okay to execute this mentally retarded offender. It's okay to execute this 16-year-old. I think what made the court change its mind is that after 1989, state by state, and in a fairly steady pace, state legislatures were restricting the death penalty so that the death penalty could not be imposed on teenagers or mentally retarded defendants. And by the time the courts decided in Atkins and Roper, at least 18 death penalty states, many of which had previously allowed the execution of these individuals, now banned their execution. And the court saw this as evidence of, objective evidence of, a national consensus that the execution of these individuals violates the Eighth Amendment. Now, there's one more group of individuals that has received constitutional protection from the death penalty. In addition to Atkins and Roper protecting mentally retarded and youthful offenders, the court has also found that the death penalty cannot be carried out on someone who is insane, that's the court's term, insane, at the time of their execution, even if they were sane at trial and at their crime and at sentencing. In 1986, in the court's landmark decision, Ford versus Wainwright, the court held there's a long-held, centuries-old common law tradition of prohibiting the imposition of the death penalty on someone who is insane. So in 1791, when the Eighth Amendment was ratified, the execution of the insane was outlawed. And you can look at some of the commentators from that period of time and see that this is so. 18th century English legal commentator Blackstone said the execution of the insane is barbaric and inhumane. Sir Edward Coke, a preeminent English jurist from the 16th and 17th centuries, says the execution of the insane should be a miserable spectacle, both against law, of extreme inhumanity and cruelty, and no example to others. So, from an originalist perspective, the execution of the insane violates the cruel and unusual punishment clause and is unconstitutional. And in 1986, when the court decided Ford, not one state allowed the execution of someone who's insane. So even looking at the national consensus based on what state legislatures are doing, the execution of the insane is outside the bounds of the Eighth Amendment. In 2007, the court reiterated this principle in Panetti versus Quarterman, and the court once again said the execution of the insane is unconstitutional and that a state cannot execute someone who's unable to have a rational understanding of their pending execution or the reasons this execution has been ordered. And in his majority opinion, Justice Kennedy said in Panetti that he had a deep concern about condemned prisoners suffering from severe mental illness that produced psychosis or delusional thought patterns. So from Ford and Panetti, we see that the Eighth Amendment also prohibits the execution of someone who's insane at the time of their execution, and insane at least means they lack a rational understanding of their pending execution and the reason for it. But what about people with severe mental illness? Someone who suffers from schizophrenia or some other psychotic disorder. Can or should the state execute these individuals? Now, you may think, oh, well, we've got that exemption for the insane. Doesn't that take care of the severely mentally ill? In reality, the insanity exemption is remarkably limited and affords very little protection to people who are severely mentally ill. In fact, Alvin Ford, who's the Ford in Ford versus Rainwright, and Scott Panetti, who's our Panetti in Panetti versus Quarterman, when their cases were remanded to the lower court, they were both found to be sane, even though they both had long, well-documented evidence of severe mental illness, including repeated diagnoses of schizophrenia or schizoaffective disorder. And, I think more dramatically, nobody's still eating, are you? Okay, because this part's icky. The Texas Court of Criminal Appeals recently found Andre Thomas, who is severely mentally ill, and who, while on death row, removed his only remaining eye and ate it. It was, in the words of the Texas court, that he was clearly crazy, but he is sane under Texas law. It's worth noting that Mr. Thomas plucked out his other eye while he was awaiting trial for the capital murders of his wife and children, whose hearts he cut out and carried around in his pocket. He's sane enough to execute. He's not exempt from the death penalty. So, although the Constitution protects teenagers, mentally retarded offenders, persons who are so mentally ill that they lack a rational understanding of their executions and the reasons for it, it does not currently protect all, or even a substantial majority of mentally ill capital defendants. Yet such mentally ill capital defendants people who suffer from schizophrenia or a psychosis, they possess many of the same qualities of other groups that the court has deemed exempt from the death penalty. For example, they often lack an understanding of the consequences of their actions. They lack or have limited impulse control. They're likely to have their illness improperly viewed as a factor to impose the death penalty as opposed as a mitigating factor to save them from death. And there's an increased likelihood that the severely mentally ill capital defendant could have, there could be a mistake made in their guilt or punishment. Think about the individual who suffers from severe schizophrenia or for some other psychotic disorder. Their actions, which may very well be caused by or be the result of their mental illness, particularly if their mental illness is untreated, their judgment, their reasoning, their understanding of the consequences of their actions is distorted by mental illness. I think there's a very strong argument that their moral culpability is less of that than someone who is not suffering from such illnesses. Moreover, the severely mentally ill are not likely to be deterred from their actions when their actions are not rational. So, like in Atkins and Roper, the goals of retribution and deterrence are not furthered by imposing the death penalty on someone with severe mental illness. Now, I wish I could say I was the first person to come up with this observation, but of course I'm not. Lots of people have made this observation. And in 2006, the American Bar Association House of Delegates adopted a recommendation on the imposition of the death penalty on persons with mental disabilities, including mental illness. And this recommendation has been endorsed by the American Psychiatric Association, the American Psychological Association, and the National Alliance for the Mentally Ill. And if you're interested, I have a citation in your materials to the report. It's at 30 Mental and Physical Disability Law Report, page 668. And I have in the little beginning of your materials, the little outline, the second paragraph of the ABA recommendation. I'm going to read it now because it's relevant to what the ABA wants to do with respect to severely mentally ill offenders. The ABA recommends defendants should not be executed or sentenced to death if, at the time of their offense, they had a severe mental disorder or disability that significantly impaired their capacity, A, to appreciate the nature consequences, or wrongfulness of their conduct, B, to exercise rational judgment in relationship to conduct, or C, to conform their conduct to the requirements of law. And the recommendation goes on to say, though, a disorder manifested primarily by repeated criminal conduct or attributable solely to acute effects of voluntary use of alcohol or other drugs does not, standing alone, constitute a mental disorder or disability for the purposes of this provision. And according to the ABA report and recommendation, this recommendation would prohibit the imposition on the death penalty with individuals with severe mental disabilities, whose mental disabilities so distort their reasoning and their thinking and their functioning that they cannot be held to the same level of moral culpability as people who commit capital offenses who are not so ill. And it really focuses on, this recommendation really focuses on the blameworthiness of the actor, and that someone with this degree of severe mental illness lacks that sufficient level of blameworthiness to be subject to the death penalty. And really, it's meant to apply Atkins and Roper to persons with severe mental illness, particularly people suffering from DSM-4 Axis 1 diagnoses like schizophrenia and other psychotic disorders. Now, an ABA recommendation is a far cry from the Supreme Court making a constitutional pronouncement. So what's the likelihood of this recommendation or something like it becoming a constitutional principle, and how is that likely to happen? As I said earlier, the imposition of the death penalty on the severely mentally ill, often offenders, raises many of the same concerns the court considered in Atkins. But it seems to me unlikely that these factors, and even the close analogy that you have between the severely mentally ill and the offenders who are exempt from the death penalty in Atkins and Roper, seems to me this is probably not going to be enough. Because when you look at the history of Atkins and Roper, it becomes apparent, or at least I think it becomes apparent, that the tipping point in those cases was the fact that 18 death penalty states, plus the then 12 non-death penalty states, prohibited the execution of juvenile offenders and mentally retarded offenders. It was the actions of these states that brought the court to the conclusion that there was a national consensus to ban the execution of these mentally retarded and juvenile offenders. Which means, for those who wish to pursue an exemption or protect the severely mentally ill, we're going to have to look at what the states are doing. That's where the court's going to look. So let me talk a little bit about what's going on in the states and where we are with respect to that. Currently, we have 15 states that now prohibit the death penalty. New Mexico and New Jersey have most recently instituted a prohibition. States, and Maryland has been in the process of greatly limiting the death penalty in their state. All death penalty states forbid the execution of someone who's deemed insane at the time of their execution. And I think that is useful evidence to show that there is an opposition to the execution of someone with very severe mental illness. However, I've only found one death penalty state explicitly banning the execution of someone who's mentally ill. Indiana, though, interestingly, has a commission that's looking at this very issue. It's the Bowser Commission. The Bowser Commission was set up when a state legislator who had been very active in this issue, she passed away, and they created this commission. And the Indiana Commission issued a report in November of 2007 recommending the exemption of the severely mentally ill from the death penalty. Now, this recommendation has not yet been enacted into law, but there have been a number of op-ed pieces in the papers in Indiana to try to enact this into law. And in particular, there's a case in Indiana, a man who is schizophrenic, who was not being treated for his mental illness, and while he was out, he committed a murder. I think he killed several people. He was sentenced to death, and the op-ed piece indicated, had this man's mental illness been treated, he would not have committed the crime for which he was sentenced to death, and that he should be exempt from the death penalty. In addition to that, all states do allow a defendant to present mitigating evidence of their mental illness to the jury as a reason to impose a sentence less than death. As you know, states also recognize that sometimes mental illness can, under certain criteria, relieve a defendant of criminal liability. Now, in Atkins and Roper, the court said 18 death penalty states plus these 12 non-death penalty states, that's what we need for a national consensus. We now have 3 more non-death penalty states, but the legislative efforts in the death penalty states do not look as significant now with respect to severe mental illness as they did in Roper and Atkins. This is not to underplay what's being done on this issue, just to say we don't have as direct, as explicit legislative protection for the severely mentally ill. This means that advocates for individuals who are advocates for the severely mentally ill are going to have to engage in the slow, messy process of state-by-state legislative protection for this class of offenders. Advocates should also, though, look at state constitutions for protection of the severely mentally ill. Prior to Atkins, there were some state justices, including 2 of our judges here in the Court of Criminal Appeals, who looked to the state constitutions for protection of mentally retarded offenders. I would urge people who are trying to find protection for the severely mentally ill to also look at state constitutions and see if that can be a basis for protection. But it does seem going back to the states and building a national consensus is an important, if not key, step in crafting this exemption. And I would caution advocates of the mentally ill to make sure they lay this groundwork before they take a claim to the Supreme Court. And in some ways, this is consistent with an approach to constitutional construction or development advocated by some legal scholars in what some call democratic constitutionalism. And this approach to interpreting the Constitution provides that courts should look, or the Supreme Court should look, at what's happening in the nation's democratic institutions, Congress, state legislatures, for their guide in shaping the Constitution of the future. And under this theory, then, it's fine to let this process of protecting severely mentally ill prisoners work its way through state democratic processes, just as the exemption for mentally retarded offenders and juvenile offenders had to work their way through the state democratic process. But in many ways, this approach is pretty unsatisfying. If the court's like the court's saying, we're going to wait for the state legislatures to take the lead and the heat for crafting this kind of advancement of constitutional protection. And while I agree it's incredibly important for the Supreme Court, our only unelected branch of the federal government, to be deferential to both Congress and state legislatures, I think that's pretty cold comfort to a severely mentally ill prisoner awaiting execution on death row who, the day we find the exemption, is a couple days too late for them. Their execution's been carried out. Imagine if the Supreme Court had said in Brown versus Board of Education, oh, we're going to wait until we have a national consensus that legally segregated public schools is a problem. We might still be struggling with the issue of legally segregated schools if that were the test. But when the court totally disregards democratic processes, there's a risk that states will reject the ultimate holding of the court and spend time trying to get around the essence of the holding, perhaps what arguably happened in response to Furman. Now, law professors, we debate and try to reconcile these constitutional constructions, and I bore my poor students with these issues all the time. But I think I was a practicing lawyer for too long, because I also look at these problems and constitutional questions from a practical point of view of how is the court going to react to a legal argument, a constitutional strategy, or a particular issue that's before it. So, from a pragmatic, if not constitutionally satisfying point of view, I think the future of a constitutional death penalty exemption for the severely mentally ill is as dependent on state legislatures as it is on the Supreme Court. As compelling as the analogies between the severely mentally ill and other vulnerable groups exempt from the death penalty, and I think those analogies are really compelling, as influential as the position of the ABA and other organizations who represent the mentally ill are, I think the Supreme Court is going to look at state legislatures. And what is happening in the state legislature, in my view, is likely to be determinative of what happens to our severely mentally ill prisoners. I'm happy to answer any questions that you all have. Thank you so much for listening. Grab my water. Yes. Oh. Yeah, this is another article that I did not too long ago. We have this exemption for the insane. You can't execute someone who lacks a rational understanding of their execution or the reasons for it. And let's say we have a prisoner who has that mental disability, and he can't do that. Well, if you give him medication, treat the symptoms of his mental illness, he now has a rational understanding that he's going to be executed, and why? And so the question becomes, can a state forcibly medicate someone so they can execute him? Or even worse, do we give the prisoner and his or her lawyer the choice? Oh, you can have your prisoner be insane and spend the rest of their years untreated and unmedicated, living with the ravages of their mental illness. Or you can treat your prisoner, which is the appropriate, humane thing to do, and the state will execute him. That's the choice that's given. There have been, South Carolina and Louisiana have found under their state constitution, no, South Carolina and Louisiana, who would think they'd be bastions of this? They say you can't do that. That violates their state constitution. So they're giving state protection. Arkansas, when Governor Mike Huckabee was governor, executed a man who was forcibly medicated to render him sane enough to execute it. I think that's one of the big issues that's going to come to the Supreme Court. I do think it arguably can strengthen the argument for exempting the mentally ill altogether from the death penalty because of this really cruel circumstance. Yes?
I was reading research on the brain.
Uh-huh.
Adolescents, teenagers, really, their brain doesn't really start kicking in full forward until about 25.
Mm-hmm.
So you haven't gone into the military when I was 18. But their particular one is I treated under people aren't getting executed because of this possibility. Something else.
Yeah, I mean, and the state could give more protection. Right now, if you're under the age of 18, so 15, 16, 17-year-olds, if they commit a capital murder, cannot be executed. But 18 and 19-year-olds aren't that much, further along in their intellectual development and their emotional development. That's a factor, currently as a factor you could argue to a jury. Mitigating factor, I don't know any states yet that have raised the age. But that's another factor, absolutely. Yes?
In both of the systems,
Mm-hmm.
and it's just Kennedy,
I knew you were going to ask that.
in addition to states look at local practice,
Mm-hmm.
regards just for that, but arguably that was a data point that was used to come up with what the policy. So it's a newer court, and some subsequent decisions have there been any plans beyond borders of the United States, and that has maybe been replaced at the court or
What we have seen is that with respect to the severely mentally ill, outside of the United States, this is considered an intolerable form of punishment. Most other countries would not tolerate this, and there have been major pushes, particularly in Europe, to ban the execution of the severely mentally ill. With respect to Justice Kennedy and Roper, he did his whole analysis, including focusing on our 18 states that ban the execution of youthful offenders, but he also had a little bit of discussion, not much, about international law. I would say that I don't think that would not have been enough. If we had had 10 death penalty states banning youthful offender executions and the world community being opposed to it, I don't think that would have been a tipping point. I think that was just an added factor, which he's gotten a lot of blowback from, which means I think for crafting future exemptions, we're really going to have to ground it within the United States for the court to get a majority on the court. I do think, though, that our court does look, and one of the things that happens with respect to the death penalty, our officials look at what's happening around the world, and to the extent the United States is out of step with most Western countries, I think it has an impact. So I do think it will have an impact. I don't see the court having that be the factor that is ultimately the decision-making factor. A question? Yeah. I don't think the ABA is parsing it out like that too much. I don't think they're answering all those questions. I think why this is in here, and you also see this in the Panetti case, which is the most recent case the court handed down with respect to exempting the insane, that while the court, and I'm guessing maybe the ABA, are looking at severe mental illness like schizophrenia, they're reluctant to move into saying, you know, someone who is a sociopath but is rationally making these choices, that they're exempt from the death penalty. So I think it's trying really to confine it to DSM-4 diagnosis, which is schizophrenia. Now, it could be that someone who's schizophrenic treats, tries to self-medicate with drugs and alcohol, and often you will find those combined together. I don't think that that's necessarily going to, the fact that someone uses drugs and alcohol, put them outside of it, but their mental illness due to drugs and alcohol alone, I don't think will be. We're getting close. I know some of you have to get back to work. I'm happy to take questions if you want to come up afterwards. Hang around. Thank you all so